In part 2 of our discussion of commercial issues surrounding the Russian invasion of Ukraine, we focus on the legal implications of a broad international divestiture from the Russian economy. Dozens of global corporations have announced that they will pause or cease operations in Russia. The ongoing divestiture is wide-ranging and touches virtually every aspect of the global economy. Companies that have existing contracts need to know whether they may break or temporarily suspend those contracts without being liable for damages for breach of contract. In answering this question, we need to first distinguish between voluntary termination of Russian business and termination that is required in order to comply with government sanctions and restrictions aimed at Russia. Where government orders make your contracts unlawful to perform, most boilerplate force majeure provisions will excuse your non-performance. A typical force majeure clause excuses a party from liability for breach if a party is unable to perform a contract, or performance is materially delayed for a variety of reasons that are beyond the reasonable control of the performing party. Force majeure clauses may cover a variety of topics relevant to the invasion of Ukraine. In addition to applying to governmental actions, force majeure clauses often reference war, embargo, labor disruptions, riots, and natural disasters. If aspects of the conflict create physical and logistical obstacles to performance, a contractual force majeure clause may apply. Even without a force majeure clause, you might still be excused from performing your contract on theories of impossibility and commercial impracticability. The oft-cited test in the United States courts for impossibility is 1. An unexpected event occurred. 2. The risk of the unexpected occurrence was not allocated by the parties in the contract. 3. The occurrence rendered performance impossible or commercially impracticable. Another legal concept that might apply is frustration of purpose. Frustration of purpose focuses not as much on the impediments to performance as it does on the purpose for which the contract was made. If the fundamental purpose for entering the contract has been altered by the unexpected occurrence, performance might still be excused even though performance has not been rendered impossible. The classic law school example is relieving the lessor of the obligation to let an apartment for the king's coronation when the coronation is canceled due to the king's illness and through no fault of the parties to the contract. These concepts are easy to apply when the unexpected event directly prevents or delays performance or fundamentally transforms the character of the contract so as to frustrate the contract's purpose. The more difficult questions come on the margins. For instance, what if you can still perform the contract, but performance has become more difficult and more costly? What if you have a contract that is ancillary to a transaction involving a Russian entity? Perhaps the ancillary contract can still legally be performed, but is now economically valueless. What if a party wishes to terminate because of the reputational harm caused by continuing to do business in Russia? Is there a theory of relief that would apply to reputational harm or brand damage? Courts and arbitrators will look at these questions on a spectrum to determine whether the variance between expectation and reality is sufficient to relieve the parties from performing their bargains. The analysis will always start with whether the parties allocated for these risks in the terms of the contract. Increased cost of performance is usually insufficient by itself to justify non-performance. One novel concept to consider is whether ESG clauses might provide a basis to terminate a contractual relationship. Contracts that incorporate company ESG policies often impose a variety of business codes of conduct that parties to the contract are expected to observe. The actions of the Putin regime may create a business environment that is inconsistent with company ESG policies. Whether those inconsistencies form a basis to terminate a contract would depend on the terms of the individual contract and the conduct of the counterparty. As you can see, there are many legal issues associated with the Russian invasion of Ukraine. Kilpatrick Townsend is continuing to track these issues and is continuing to help clients to evaluate their compliance obligations as well as their contractual options related to the Ukraine invasion. Please refer to our homepage where our latest client alerts and updates can be found. Thank you.